Good evening. I trust you are all well. Thank you for joining our live webinar. Today's topic, urgent High Court applications in care and guardianship matters. How does it work? Very interesting topic, an important topic to know about, not necessarily only for the public, parents, people that have children, and who may have issues regarding care and contact, visitation, consent, and so on, but also for legal practitioners, attorneys, advocates, candidate legal practitioners, and so on. In my career over the last 20 years or so, I've maybe done a few hundred urgent High Court applications regarding care and contact, maybe not so much, but quite a lot. And it's one field of law which many practitioners do not necessarily understand. The principles of urgency is obviously the same as in any other matter of urgency. But nonetheless, if you are dealing with a matter concerning a child, obviously we're dealing with different dynamics. We're not dealing with, for example, the urgent return of a motor vehicle, an expensive motor vehicle that has been taken by a third party, or the urgent stay of execution of a judgment, of a warrant, or the urgent sale of a home, and so on. So, urgent matters regarding minor children basically focuses on dealing with a dispute regarding a minor child, and for the court as the upper guardian of minor children to make an order. Now, I will obviously elaborate upon it a bit more in detail, but for argument's sake, let's say a parent is refusing another parent access to a minor child, contact to a minor child, and now you would like to enforce your rights to have access to your minor child. Now, there are various ways of doing that. One way would be to send a letter, go to an attorney, have the attorney send a letter to the other party and see what the other party does. Another option would obviously be to go to maybe to the children's court, and they can do an investigation. There are various mechanisms and ways in which to deal with it in order for you to obtain contact rights to your minor child to enforce it. Or the other way would be to approach a high court urgently, on an urgent basis, and advising the court and telling the court that this is urgent. I need to have contact and access to my minor child as soon as possible. Please assist. And the High Court, as an upper guardian of the minor child, would obviously look at the matter and make a decision whether or not to make an order that contact should be restored or contact should be allowed, or whatever the case may be. I'm just speaking generally now, and once we get to the examples, we can unpack it a bit further. But that's the topic of today's discussion, the flavor on which we will focus on. If you have any questions, feel free to post it on the Advocate Mohammed Abduroaf Facebook page. I'll be keeping an eye on that. And at the same time, you're welcome to join in via Zoom. If you are on Zoom, I'll be happy to entertain you, and we can interact where that is concerned. Alternatively, there's a WhatsApp number. It should be on the screen at some point, and maybe not today, but maybe tomorrow. Once that message has been sent to us, we will obviously have to vet it first, and we will obviously deal with that. So let me first deal with a few questions, and then we can deal with the pragmatical aspect thereof. But I'll first deal with question one, and maybe there we can take it from there. Okay, excuse my English. I have been living with the father of my child for the past 10 years. We have a 3-year-old daughter together. Our relationship became toxic, and I decided to leave our home last month and live with a friend. I had to leave my daughter behind. I was always a primary caregiver. The father now only wants to allow me supervised contact. I now have my own apartment and a room for my child. How can I get the child back in my care? The police does not want to get him involved. Okay, let's deal with the scenario. Typical scenario, something that comes before lawyers, family lawyers, all the time, on a daily basis, weekly basis. The parties were living together, girlfriend, boyfriend, partners in a relationship. Here in our scenario, they were not married. 3 years ago, they had a child. The child is 3 years old. Things did not work out. They start arguing, they start fighting, they cannot live together. The mother decides to move out. She can't handle it anymore, but obviously she has to leave the child behind because she does not have a place for the child to live with it for the time being. The father, of course, in his view, he now wants to keep the child, and should the mother want to have contact with the child, she must now visit the father's home, and she cannot take the child with her, and he wants to supervise the contact and care. Obviously, his agenda, I'm not judging anyone here, but his agenda is obviously now that he wants to become the primary caregiver of the minor child, and he does not want the mother to take the child away. The mother has a new apartment. She says here in my scenario that she was a primary caregiver of the minor child, meaning that she's the one that cared for the child. The child is ill, homework, schoolwork. Okay, the child is 3 years old. Maybe potty trained the child, taught the child how to speak, how to walk, etc. The one that cared for the child primarily. The father, of course, also assisted. Now she has her own apartment. She wants to take the child now back. The father does not want that to happen. What can she do? Okay, obviously, this is a serious matter. And my belief is that children's matters takes preference over matters concerning property, money issues. Children are our future. They're the future of this country. If there's a dispute in the court regarding a few million rand, somebody took your money from you and they potentially leaving the country, and you want to get a court order stopping the plane from leaving the country because your diamonds or your gold is with that person. Important, we're losing a few million rand. The High Court can, of course, be approached for that. It's quite urgent. But I believe when it comes to matters concerning children in our future, the court should give more priority to those type of matters. So if there are two matters in the queue before a judge, one regarding a minor child and one regarding commercial urgency or property issues, which is also urgent, we first deal with a matter concerning a child. That's my view on the matter. Okay, this type of matter, typical, the mother obviously has to present a case, and she needs to she needs to prove to the court that she was a primary caregiver and that the minor child will be better in her care, despite the parties having been separated. And the father, if he believes the minor child will be better in his care, he would obviously have to do that. So what happens basically, let me unpack this. I'll spend quite some time on the scenario. And then at the end of the practical aspect on how the matter is taken to court, I will deal with the merits and how I'll put two advocate hats on, one advocate hat for the mother and the other advocate hat for the father. The mother may approach an attorney. The attorney may urgently write a letter to the father and stipulate, these are the facts of the matter. The minor child must be returned to our client. The client has accommodation and so on. The father might respond to it or he might not respond to it. Time is running out. Let's say the father does not respond to it or the parties cannot come to a resolution. The mother has full right under these circumstances to approach the High Court urgently, outlining all these facts. So what basically happens is she drafts a notice of motion, or attorney or advocate will draft a notice of motion stipulating that what she wants. In there it will stipulate that she would want the minor child to be immediately returned to her primary care, and maybe for the father to have reasonable contact, maybe every second weekend, maybe every day after school, or maybe daily contact, whatever the case may be. But the minor child will be cared for by her primarily. That's what she'll basically be asking for. With that application comes an affidavit. That affidavit will stipulate who she is, who the father is, who the child is, the history. Okay, they were together for 7 years before the child was born. That is basically the important date, once the child was born. And then issues during the relationship, who cared for the minor child, and how it came about now that she left the home. So a big chunk of the drafting would deal with what happened in the last month or a week before that. How it came about, why the mother left, the circumstances, where did she go to, what contact she had when she left, how was contact limited, etc. Her current circumstances, her new flat, can the new flat accommodate for the minor child, all those specific circumstances will be outlined, and why she believes this matter is urgent. Of course, it is quite inherent urgent, but she needs to deal with that. It's urgent because the father cannot care for the minor child, and so on. And she wants a minor child to come back to her. So each case is different, all facts are different. We're dealing with a 3-year-old child. There isn't necessarily schooling, etc. So the facts will basically deal with issue concerning caring for the minor child. Okay. The mother drafts that application, gets served upon the father. Obviously, on the application, there will be a date where they will appear before the urgent judge. Usually it's about a week, giving the father adequate time to file his opposing papers. The father will come with his attorney, whatever the case may be, and he will respond to what the mother has to say. Maybe he files a counter application stipulating that he wants to have primary care, whatever the case may be. But he will basically deal with the allegations made by the mother. He'll say, I know I disagree to this. This did not happen. These are not the facts. I was a primary caregiver. I cared for the minor child. The mother was the one working. I was the one that did everything. That's why the mother left in the first place, because she was not a primary caregiver, whatever the facts are. Then the mother will get an opportunity to reply to what the father said. So the way I explain to my clients is, in your founding affidavit here, the mother will say A, B, C, and D. Now, A, B, C, and D will generally be who she is, the facts of the general history of the matter, etc. She will say A, B, C, and D. The father will respond to that. But the father will deal with A, B, C, and D, and he will add on E, F, and G. New stuff, new allegations. Then the mother will only get an opportunity in the replying affidavit to only deal with the new allegations, E, F, and G. She can only deal with that. She cannot get a second bite at the cake in re-dealing with A, B, C, and D because the father disputes it. It does not work that way. The basic idea is for the court now to know what is in dispute, what needs to be dealt with, etc. Now she dealt with E, F, and G, whatever the case may be, in a replying affidavit. Now, both parties outline the case, the allegations to the court on paper format, and the court will obviously read it. The judge will read it. The urgent judge on the day, he will obviously read it. And sometimes parties file heads of arguments, short arguments as to what the case is. The advocates will do that, or the attorneys, depending upon who's appearing before the judge. And the judge will ultimately listen to arguments and make a decision there and then. Usually in children's matters, we would like to get the Office of the Family Advocate on board, or some expert or some specialist. So usually the court will make an interim order. The court will not make a final order. The court will make an interim order, stipulate, you know what, I see this dispute, I'm making the following provisions. The minor child should maybe remain with the dad until the family advocate gets on board, but the mother can have unsupervised contact. She can take the child with her to her place and so on, whatever the case may be. But the court would have to make a decision. Or sometimes the court say, child goes back to mom. Child is quite young. Mom is a primary caregiver. Father works all the time. But I'm still asking the Office of the Family Advocate to get on board. Okay, so I hope that assisted you with that is concerned. If you have any questions, feel free to pose it. I am happy to answer that. Now, let us unpack. What would be my arguments for the mother? Obviously, the mother's arguments would be that she was a primary caregiver for the minor child. She cared for the minor child all the time. She has the capabilities. And her other argument would be that the father does not have those capabilities. He knows how to change the diaper. He knows how to play with the child. He knows how to take the child to McDonald's, play on the swings. But when it comes to staying up late at night, feeding the child, making food for the child, dressing the child, medicating the child, etc., pacifying her, the father does not have those skills. And besides that, he works. His temperament does not allow for that. He works online at night, whatever the case may be. So those are her specific scenarios, her examples of why she can care for the minor child better and the father cannot. The father, of course, his argument most probably would be that he was also the primary caregiver of the minor child. It's very weird that when there's a dispute regarding primary care, both parents seems to want to argue that they were the primary caregivers. But of course, the court will look at the facts. I mean, you can call something something, but if it's not that, it's not that. You can't call an apple a pear. It's an apple. It might look like a pear, but it's still an apple. And that's what the mother will obviously try to explain to the court. And the father, the father will explain to the court that he can care for the minor child, he has cared for the minor child. The mother's new flat is inadequate. The minor child is used to the specific environment. For argument's sake, they said there's a park around the corner, the child's toy is over here, it's bigger. It could be a nanny, au pair, whatever the case may be. And he has the capabilities and the temperament to care for the minor child, and the mother does not. And because for the last month, he cared for the minor child quite well. Then he might come with certain advantages, which he has. For example, that he works from home, he done online parenting courses, whatever it is. But he will try to put his best foot forward, and he will try to convince the court that he can care for the minor child much better than the mother can. If he has a counter application, He might argue that he wants a court order stipulated he has primary care of the minor child, and the mother can have supervised. In this case, he might dispose of that specific argument, or he can argue that the mother should have reasonable contact every second weekend, and should the minor child go to school, off school holidays, and so on. So I hope I assisted the specific question and unpacked the whole issue concerning urgent High Court applications. It can be done. I made urgent High Court applications with a client. The attorney came to my office on the Friday and we were in court on the Saturday. Or they came to my office on the Sunday and we were in court on the Monday. It all depends upon the urgency of the matter, the circumstances of the case, and so on. The judges are there to listen to you, to wait for you. They are there. There's always a judge available in the High Court, 24 hours a day, 7 days a week. Yeah, in the Western Cape High Court, they change shift on a Friday at 5 o'clock. So try not to launch your application at 4 o'clock on a Friday. He might tell you, you know what, my shift ends at an hour's time with another judge at 5. And then the judge at 5 o'clock say, you know what, go back to the judge at 4 o'clock because he was on duty when you launch your application. I'm not saying that will happen, but just work out the time really well. Come time you to the courts and know how things work. Now, the next question 2. My daughter is 7 years old, and according to the mother, she does not want to have sleepovers at my home anymore. Her reason is because I remarried last month. According to the divorce order, I have visitation every second weekend and half school holidays. What can I do to restore my rights? I believe the mother is coaching my daughter. Another typical scenario whereby the parties divorce, one parent maybe remarries, and there's some jealousy. I'm not saying this is the case, but that sometimes happens, or the child is jealous, and because now maybe there's a new stepchild, a stepsister, or stepbrother in the mix. The father married a woman that has a child, and of course he also has a child. And now maybe the minor child does not like going to visit the father's new home and the father's new family, and issues arises. The advantage we have here is for the father there is a court order, and the court order must be dealt with. The child is 7 years old. Now the law says, of course, you have to listen to what the child has to say, but a 7-year-old child is not necessarily mature enough to determine what is best for her. It's quite little. Because I'll ask a question to the mom. What if tomorrow the child says, Mom, I do not want to go home to you on a Monday morning because father's taking us to McDonald's, or the father bought the minor child a present, and the child does not want to live with the primary caregiver because life of the mother is strict, his homework, his schoolwork, and so on. So we do not necessarily listen to what a 7-year-old child has to say. We listen, of course, she might mention important things, for example, abuse, neglect, and so on. But we do not necessarily focus on what the minor child's preference is. It doesn't make logical sense. What if a father can care for the minor child better, educational-wise, financially, and so on, because he has the temperament, the capabilities, and so on, and he always has been doing that. Now the child said, no, I have to live with mom because mom has a swimming pool. It doesn't work that way. We need to focus on what is in the minor child's best interest. If the mother is coaching the minor child, and if the mother is involved, that's unfortunate. I hope that is not the case. But my advice to the specific questioner, the father, I would actually advise you maybe to resolve this matter quickly, have the mother agree to the minor child being interviewed by a professional person, a social worker. You're entitled to contact. The child must actually come to you. There's no doubt about that. But maybe try to resolve that matter. Maybe spend a few rands on a social worker who can consult with the minor child and just to look into what is the reason why the minor child is doing what she is. A social worker, a psychologist, someone that knows how to deal with minor children. Before you force a minor child. And if it comes about that the minor child seriously is having apprehension, anxiety because she has to visit the father's place, and maybe under those circumstances be a bit careful. There might be a way of dealing with this matter. Maybe the father can pick the minor child up, they can go together to a park and not bring the minor child to the house, and we can work towards introducing the minor child to the step family, as is the facts over here. However, if it is clear that the mother is behind it and the child is just being childish, like any child would be, but jealous, then under those circumstances, I would advise you, if the mother is not willing to cooperate and have the child come to you and make sure the child knows that the child needs to be with by the dad, it's his time, and then a court application to compel the mother or force the mother to bring the minor child or allow you to have contact with the minor child. If the minor child still persists, an application for contempt of court can be made. You have a court order. I'm also one of those advocates. I'm very, very cautious in forcing certain things if they could potentially be red flags. I'm a very cautious advocate. So I see a court order allowing you contact. However, if the minor child, if there's red flags and a minor child, or the allegations that the minor child does not want to see you, let us first look into that. It's very important to look into that. Especially a 7-year-old child. If the child had to be a 3-year-old child, I'll say, you know what, unless something quite serious is happening over there, I don't think you should necessarily listen to a 3-year-old child, because many times a 3-year-old child cries because the child does not want to go to that parent, and then when the swap takes place, the child cries again, he does not want to go to the other parent. So each family is different. So I hope that answered that specific questioner's question. And the third question, I do not see any Facebook Live questions. If there are any, you're welcome to pose it. I'll be happy to answer it. I believe the courts favors mothers over fathers when it comes to custody. Is that correct? Typical question. You know, sometimes I get the opposite, where the mother says that I believe the court favors the fathers, or depends upon the court. You know, maintenance court, the court might say no, they favor the fathers, or the father will say the court favors the mother. So let me first deal with that question. Is that correct? No, it's not correct. Yes, as any human being would be, some people will favor a male, a female, a blonde, a brunette, a lady. This is how human beings are, but there is no principle, and there's no blanket rule or practice in the court system that one gender is favored above the other. That there is no such thing. There might be one judge or one magistrate that on that day he might be grumpy and you think he favors the males, or you think he may favor the females. Or there might be a judge or magistrate that does favor males or females. I do not know. But there is no, where I can say, general preference. I've been practicing now almost for 20 years and I've never seen that. Obviously, if a child is a month old and the child is with a mother, a father can try how hard, unless the child has been neglected, the court will make an order that the child should remain with the mother, logically speaking. The child gave birth, the mother gave birth to the child, the mother is breastfeeding the child, the mother is caring for the child, and so on. So that makes logical sense. But if the father can prove that the child would be better cared for by him, obviously that is an important factor to consider. So there is no preference. I do not believe there is. I believe there are some judges or magistrates that would have historically have favored one or other gender. Some judges may favor the male. Some judges may favor the female, depending upon the facts. But I don't see that often. I might just be disappointed because the judge didn't find in my client's favor, and then I would say, he prefers females over men, but I wouldn't do that also. Okay, the second part of the question is, I want custody over my daughter. However, the mother says that at best I can have her 3 weekends a month. Okay, that's 6 days a month. The mother works late every night and collects the child at daycare very late. I work from home. Any advice? Okay. So you have to look at your circumstances and the mother's circumstances. I do not automatically, just by default, believe that a client that comes to my office, automatically they have a clean case and that they're entitled to whatever they want because they are paying lawyers and so on. You have to look at the matter. Why is your circumstances much better than the circumstances a minor child is in when living with a mother? That's very important. We have to look at that. If you can prove to me, or demonstrate to me at least, you don't have to prove anything, but demonstrate to me that the mother working late and the child has been neglected, and you, on the other hand, have a plan B that should the minor child live with you, you will not work late, the child will be better cared for, you have the capabilities to deal with homework, the facilities available, and so on, that the child will thrive living with you. Wonderful, that is great. So if you can do that, if you can prove to yourself, firstly, that the child would be better cared for in your care as opposed to the mother, despite her working circumstances and so on, the child would be better cared for by you, that would be great. So that's my advice to you. Look at the situation. And if it comes about at the end of this analysis, speaking maybe to a social worker, a psychologist, somebody that deals with kids, speaking to a professional on this, and at the end of this analysis, you come to the conclusion, you know what, I think it would be better for the minor child to be cared for by me. She would better in education, schooling education, better lifestyle, everything, closer to friends, amenities, etc. And the mother is not willing to sit on the same table and discuss it, Try mediation. If mediation doesn't work, of course, then you have to take the matter to court, because at the same time, you would not want your child to be in a worse position, or if there is a better position available. So if the child living with you is better than living with a mother, you as a responsible parent should move towards that. And the same way, no parent would want a child to be in a negative position, in a worse off position. So if you have the capabilities, you need to enforce that, or try to at least fight to have the minor child living with you. Because the alternative would be the minor child living with a mother, and you know that the minor child could live a better life living with you. Okay, I'm saying the same thing a few times over, but I'm certain you know what I'm saying. Okay, we do not have any questions today. I've typed in question 1 for the live Facebook questions. If you have any questions, you know the portals to make use of. I hope that you will do so, and at our next webinar we can deal with that. We are back online tonight again at 7:30 dealing with mediations. Feel free to join us then. Have a lovely day.